this Court's cases go farther.
Can I follow up with that just on the facts of this case? Because as I understand your argument, we do have both notice and consent under these circumstances, given that these individuals as third parties are not just people in the world, they are employees of the recipient of federal funds. And so to the extent that the recipient of federal funds has made clear with the federal government that it's going to require its employees to comply with RLUIPA and not violate people's rights, then when those employees choose, consent to accept a job with that employer, they are thereby consenting to follow those agreements. Is that right?
That is exactly right. And I think that's why when this Court has had these cases, Salinas, Dixon, Hess, Laudani, it's a whole line of cases involving officers, agents, employees, subcontractors, where this is chain of privity.
Yes.
Every time the Court has I think, actually seen that in Salinas that there was no serious doubt. This is not a hard case.
Because chain of privity is a classic contracts concept, so that even if you thought that contracts was governing this, we have individuals who, for example, I suppose, let me just give you a hypothetical. What if the prison in this situation actually appends to its employment contract all of the conditions that it has agreed to with the federal government? And of course, the prison can only operate under its employees' not direction, but because there are employees. In other words, the prison doesn't have its own activity. So to the extent that it agrees with the federal government that it's going to comply with RLUIPA, it's saying I and my employees, the agents that I employ, are going to do this. And so let's say the prison actually appends to its employment contract all of the conditions that the federal government requires for the receipt of federal funds. So the person who is choosing to be an employee is totally apprised of what it is that is required as a condition of employment. I understand your argument to be that that would be sufficient, even if we assume that there has to be notice and consent to satisfy any such agreement.
Of course. And I think what this Court has said, if I could, in Russ versus Sullivan and then in Alden versus Maine as to state officers specifically, is when you go into this job, when you go into this line of work and you voluntarily agree to be an officer in a federally funded state program, then yes, you implicitly, you necessarily take it subject to the conditions that Congress has attached to the funds.
Thank you.